If you are a naturalized United States citizen, there is a very real chance that over the past few weeks you have seen headlines, viral posts, or short videos claiming that US citizenship is no longer secure. Some posts suggest that thousands of naturalized citizens are about to lose their status. Others imply that a new government policy has quietly rewritten the rules overnight for people who spent years navigating background checks, interviews, paperwork, and long waits to finally become citizens. This kind of messaging hits deeply. Citizenship represents stability, belonging, and protection. So when that status appears to be under threat, even indirectly, anxiety spreads quickly. But here's the problem. Fear travels faster than facts. And right now, fear is doing most of the talking. To understand what is actually happening, we need to separate three things that are often blended together online: political rhetoric, media framing, and legal reality. These are not the same, and confusing them creates unnecessary panic. Let's start with the legal foundation, because that is where the strongest protections exist. Once US citizenship is granted through naturalization, it is not conditional. It does not expire. It is not reviewed annually. It is not revoked because of elections, executive orders, or changes in political priorities. The law treats citizenship as a permanent legal status. The only way it can be taken away is through a formal process known as denaturalization. And that process is far more limited, slower, and narrower than most headlines suggest. Denaturalization is not a new concept. It has existed for decades and has been used sparingly under administrations from both major political parties. The basic legal theory is straightforward. If citizenship was obtained through serious fraud or intentional deception, and that deception was material to the approval of the application, the government can ask a federal court to revoke it. That last part matters enormously. This is not an administrative action. It is not something an immigration officer decides quietly. It is not triggered automatically by databases or algorithms. Denaturalization cases must be filed in federal court, argued by Department of Justice attorneys, and decided by federal judges. This alone creates a natural limit on how many cases can ever move forward. Judges require evidence, due process, and legal justification. There is no shortcut. Despite this reality, many recent headlines focus on one statistic: claims that denaturalization cases have increased by as much as 16,000%. That number sounds alarming. It suggests a massive surge and an aggressive policy shift. But numbers without context can be deeply misleading. For many years, the number of denaturalization cases filed nationwide was extremely small, sometimes fewer than 10 cases per year. When you start from such a tiny baseline, even a modest increase produces a massive percentage change. Going from 10 cases to a few hundred looks explosive in percentage terms, even though the actual number remains minuscule. There are currently over 25 million naturalized US citizens living in the United States. Even at higher recent filing levels, denaturalization affects a fraction of that population. Statistically, it is insignificant for the average citizen. But statistics don't generate clicks, percentages do. Another critical point missing from online discussions is how selective the government must be when choosing which cases to pursue. The Department of Justice does not have unlimited resources. Each denaturalization case requires years of investigation, document collection, witness interviews, legal review, and courtroom litigation. Many cases involve events that happened 10, 15, or even 20 years ago. Records must be located, evidence reconstructed, and memories tested. Because of this burden, prosecutors focus almost exclusively on cases where the evidence is strong, the fraud is clear, and the legal theory is likely to survive intense judicial scrutiny. Weak or borderline cases are rarely filed. This is not about volume. It is about certainty. There is also widespread misunderstanding about what actually qualifies as fraud in this context. Fraud does not mean making a mistake. It does not mean misunderstanding a question. It does not mean relying on incorrect legal advice. Fraud means intentionally lying or concealing information that would have changed the outcome of the application. Examples include hiding serious violent crimes, concealing involvement in persecution or terrorism, fabricating asylum claims, or lying about identity in a way that was central to eligibility. These are the types of cases courts consider material. Without those facts, citizenship would not have been granted. That causal link is essential. By contrast, minor discrepancies, old traffic issues, paperwork errors, or misunderstandings do not meet this standard. Courts have repeatedly rejected attempts to revoke citizenship based on technicalities or harmless omissions. The legal system recognizes that immigration processes are complex and that human error exists. Even when a denaturalization case is filed, the outcome is far from guaranteed. The burden of proof rests entirely on the government. Prosecutors must prove intent, materiality, and causation. Defense attorneys can challenge evidence, cross-examine witnesses, and argue that the alleged misrepresentation did not affect the final decision. Federal judges approach these cases with caution. Citizenship is treated as a fundamental right, and courts are reluctant to strip it without overwhelming justification. This is not a loophole. It is a safeguard built into the system. Another common misconception is that denaturalization automatically leads to deportation. In reality, these are separate legal processes. Even if citizenship is revoked, additional proceedings are required before any removal action can occur. Each stage includes its own legal standards and opportunities for defense. So why does the public conversation feel so urgent right now? Part of the answer is politics. Immigration remains one of the most polarizing issues in the country. Strong language energizes supporters, even when it oversimplifies reality. Media outlets, especially online, often amplify that language because it drives engagement. Another factor is social media. Complex legal processes are reduced to short clips, captions, and emotionally charged summaries. Nuance does not survive well in that environment. As a result, many people are left with the impression that something sudden and dangerous is happening behind the scenes, when in fact the legal framework remains largely unchanged. This does not mean the issue should be ignored. Awareness is healthy. Understanding how the law works is empowering. But panic is not productive. If you are a naturalized citizen who knows there were serious unresolved issues in your immigration history, consulting a qualified attorney is a reasonable step. That does not mean you are in danger. It means you are being informed. For everyone else, there is no evidence to suggest that ordinary naturalized citizens are at risk. Citizenship is not being quietly dismantled. It is not being reviewed en masse. And it is not being revoked based on political mood swings. The system is slower, more constrained, and more cautious than headlines would have you believe. In moments like this, the most important thing is to slow down, verify information, and resist emotional reactions. Law operates on evidence, procedure, and precedent, not on viral narratives. This is Immigration Bulletin Hub, and our goal is simple: cut through fear, explain the law clearly, and give you facts you can trust. If this breakdown helped you, subscribe for future updates and leave a comment if you'd like us to cover specific immigration topics next.